this particular witness was all about, which is important as far as an aggravating factor when it comes to, I would imagine, the heinousness of the crime.
Absolutely. It goes to heinousness of the crime. Another aggravating factor has to do with attempting to injure or kill a great number of people. And that's what the prosecution has shown all week long, by bringing in victim after victim after victim to tell their story, by showing the specifics in where he shot, how much he shot, the number of bullets, the number of magazines. The prosecution is handling that part of the case brilliantly. It goes directly to at least a couple of the 7 aggravating factors that they have set forth.
Here's another question for you. The defense throughout this case, really, has made a point of objecting to a number of the things being introduced and evidence being introduced by the state. And they're continuing to suggest that by allowing all of this in, it's creating a situation where it's prejudicial against their client, it's cumulative. The judge has already told them that I understand that you're objecting to all of this. I've made a note for the record that there is a continuing objection to all the evidence being put on by the state, but they continue their verbal objections. And I take my cue sometimes from folks online, a lot of them wondering why they keep doing that and getting a little sort of put off by it. I wonder if you think that's the right tactic and why perhaps they're continuing to make verbal objections to the evidence.
I think it is the right tactic. I think the defense is doing a good job in a very difficult space here. You know, the defense doesn't have a lot to do right now. They can't cross-examine any of these witnesses effectively. There's nothing to ask them. They're making their record for appeal. It's fine that the judge has said you have a standing objection and all of that, but you have to be very careful when you go up on appeal. You have to be absolutely sure you have made an objection on the very specific piece of evidence you want to bring up on appeal. So they're recording every single one of those, and they're also breaking up the flow a little bit of the prosecution's case, which maybe some people complain about, but I could see that as being strategy as well.
Now, I want to talk a little bit about the difficult job that the defense has, as you mentioned, but first I want to play some tape. Earlier today, we heard from some first responders who went to the scene, which some of them got emotional, which you don't often see. And we also heard from the medical examiner, and that's what I want to play right now. His testimony was particularly gruesome because what he was talking about, obviously, was the cause of death and the type of wounds that these victims received during this, which were gruesome. So let's take a quick listen, then I got a question for you.
Which of the 8 gunshot wounds would have been, in your opinion, fatal in and of themselves?
One is to the head and neck, to the torso, to the chest, because it's perforating lungs and liver and cause extensive bleedings. Wounds to the extremities contributed also to the death because it caused bleeding, extensive bleeding. But the most lethal is to the head and to the torso.
Do you have an opinion as to how long Martin Duque Aquiano would have lived before he would have died of these wounds?
Couple of minutes.
Now listen, Rich, I mean, this, it's indicative of the type of testimony we've heard throughout this trial, just the gruesomeness of the act itself. And you talked about the difficulty of the defense here, so put yourself in their shoes, Richard. What's your approach here? I mean, so far, and these are very experienced attorneys, and I think they're doing a fantastic job. At some point down the road, we're talking maybe 3 weeks, they're going to get an opportunity to begin presenting their case. What is their strategy? Do they try to curry some sort of sympathy for him, or just present this evidence straightforward that he's had a troubled background, there are some mental health issues? The fact that he's 19, I think, would have to play into it as well. What's the approach that they take?
I think they have only one avenue here to avoid the death penalty, and that is to establish the mitigating factors that they're going to bring up in their part of the case. So right now, there's not much they can do. The evidence is coming in on this horrible, heinous massacre, and the evidence is overwhelming, and it is easily establishing every single one of the aggravating factors suggested by the prosecution. And all the defense can do is lodge some objections for the record on the points they may appeal and wait for their turn, because when they get to their turn, they're going to go into the history of the defendant. What made him into a person who could do this act, and try to get the jurors to have some sympathy for him, that they would at least spare his life.
Now, you know what's interesting is what this jury is going to be tasked with doing, Richard, is actually weighing the aggravating factors against the mitigating factors. So the prosecution keeps arguing, hey, we need to keep bringing in as much evidence as we possibly can. Every time the defense tries to limit them in some way, they continue to argue, look, this is a test for this jury to weigh aggravating versus mitigating. So we want to continually to bring in as much as we can to make our side as weighty as possible. Do you think, though, there is a point, now the judge continually rules in favor of the state, bring it in, let it in. Do you think there is a point where this may become cumulative and may be problematic on appeal?
Yes, I think they could go overboard. I think the prosecution has to be careful, because if the evidence becomes not so probative and more prejudicial or cumulative, as you say, it could be an appeal point. And also beyond that, Michael, I think the prosecution has to be careful of not presenting so much evidence that they almost dull the jury to the horror of all of this. You know, the jury is seeing so much of this in such graphic and horrendous detail that after weeks and weeks and weeks, they could be numb to the entire thing. And you don't want that when it's their turn to render a verdict.
Yeah, it's almost like a human response to it. At some point, you got to put up a shield and kind of deflect. I know I've had to do that here, listening to it in the studio. All right, Rich, we do have to take a break. Stand by. We got a lot more to discuss about this case coming up next. Emotional testimony from law enforcement officials who were the first to respond to the shooting at Marjorie Stoneman Douglas High School. And it is our testimony of the day. And then later in our Talkback segment, as week one of the penalty phase wraps up, we want to know if you have any lingering questions. I know you guys have many of them. If so, leave us a comment on social media, and we're going to share the answers later on in the show. Keep it right here on Court TV.